This is Syndication Attorney Field Notes. I'm Tilden Moschetti, and I'm a syndication attorney. Today's field note is about the limited partnership agreement in a Regulation D private fund. Here's the scene. A sponsor sits down to raise a Regulation D private fund. The PPM is nearly done. And then someone hands over a long document called the Limited Partnership Agreement. And the sponsor says, "Isn't that just the paperwork behind the PPM?" No. And this is the mistake I keep seeing. The Limited Partnership Agreement, the LPA, is the contract that actually runs the fund. It's not background formation paperwork you file and forget. It's the operating engine of the fund. Let me put it in plain terms. The LPA controls three things. It controls how capital comes into the fund. It controls how cash goes out to investors. And it controls how much power the sponsor's entity, the general partner, holds over that money. Inside that, the LPA sets the sponsor's economics. It sets investor rights. It sets voting limits. It sets redemption mechanics, and it sets the distribution waterfall, which is just the order in which cash gets paid out. So the LPA is a living operating contract. It's the engine room of the ship. The passengers rarely go down there, but every real decision about moving the money forward happens in that room. Now, why is the mistake so easy to make? Because in a private placement, the documents travel together. The PPM, the LPA, and the subscription agreement usually show up as one big packet. Investors read the PPM closely because the PPM tells the story and describes the risks. The LPA is long and technical, so it gets treated like boilerplate. It just rides along in the back of the folder. But those documents do very different jobs. Let me draw the line. The PPM is the warning label. It discloses the strategy, the terms, and the risks. It's the material you read before you decide to get on the ship. It describes, it warns, but it does not govern the mechanics. The LPA is the rule book. It's the binding contract among the partners. If there's ever a question about how a fee is calculated or how a distribution should have been split, the answer comes from the LPA, not from the marketing summary. The distribution waterfall is a formula, not a preference. And the subscription agreement is the ticket to entry. Investors don't usually sign the whole LPA line by line. They sign the subscription agreement, which admits them into the fund and binds them to the terms of the LPA. One more thing, filing a Form D is a separate securities step. It's how you claim your exemption. It does not create the fund's operating rules. The LPA does that. Let me give you a quick example so this lands. Say a sponsor is running a debt fund. Loans turn over on a faster cycle, and the PPM tells investors they'll have some liquidity, some ability to redeem. But the sponsor grabs an LPA built for a private equity fund. That kind of fund often locks investor money for 7 to 10 years because the assets are long hold. The redemption mechanics in that document are weak or non-existent. In good times, nobody notices. The mismatch is invisible. But then the market gets tight and investors start asking to redeem. Now, the sponsor learned something hard. The PPM said one thing, but the LPA says another, and the LPA is the binding contract. The math in the LPA is what controls. The legal text has to match the operational reality. When it doesn't, the contract wins and the marketing summary becomes a problem. So here's what not to assume. Don't assume an LPA you found in a public filing is a neutral template. It's usually a specific funds negotiated contract built for a specific strategy and a specific investor. Copying it is like borrowing someone else's prescription glasses. Don't assume the PPM controls how fees, distributions, or redemptions are calculated. That's the LPA's job. Don't assume redemption gates, suspension rights, or a redemption queue exist in your fund. Those tools only exist if they're written into the LPA in advance. And don't assume that giving limited partners broad voting rights is always better for investors. Too much operational control can blur the passive investor role, and that role is tied to their limited liability. Narrow voting rights can actually protect the investors, not just the sponsor. So here's the field note for today. The LPA is the operating engine of a Regulation D private fund. The PPM is the warning label. The LPA is the rule book. The subscription agreement is the ticket to entry. In good times, a great LPA is invisible. In bad times, it becomes the loudest voice in the room. It's the document everyone reads closely when there's a dispute or a downturn. So the LPA should match your actual strategy, your capital structure, your liquidity promises, and your real economic deal, not somebody else's. The longer written version of this is in the show notes. I'm Tilden Moschetti, and that's today's field note.